Step 5 in steps of the process per a criminal justice process overview, chapter 1 of Crim procedure. Step 5 is filing the complaint. Assuming that the police decide to charge and that decision is not overturned in a pre-filing prosecutorial review, the next step is the filing of charges with the magistrate court, which must be done prior to the arrestee's scheduled first appearance. See step 7 infra. The initial charging instrument commonly is called a complaint. For most offenses, a complaint will be a fairly brief document. Its basic function is to set forth concisely an allegation that the accused, at a particular time and place, committed specified acts constituting a violation of a particular criminal statute. The complaint will be signed by a complainant, a person who swears under oath that he or she believes the factual allegations of the complaint to be true. The complainant usually will be either the victim or the investigating officer. When the officer complainant did not observe the offense being committed but relies on information received from the victim or other witnesses, the officer ordinarily will note that the allegations in the complaint are based on information and belief. With the filing of the complaint, the arrestee officially becomes a defendant in a criminal prosecution. Step 6, magistrate review of the arrest. Following the filing of a complaint and prior to or at the start of the first appearance, see step 7 infra, the magistrate must undertake what is often described as the Gerstein review, as prescribed in the Supreme Court decision in Gerstein v. Pugh, FNA, page 161. If the accused was arrested without a warrant and remains in custody or is subject to restraints on his liberty as a condition of station house bail, the magistrate must determine that there exists probable cause for the offense charged in the complaint. This ordinarily is an ex parte determination, similar to that made in the issuance of the arrest warrant. If the magistrate finds that probable cause has not been established, she will direct the prosecution to promptly produce more information or release the arrested person. Such instances are exceedingly rare, however, since a judicial probable cause determination already has been made where an arrest warrant was issued. A Gerstein review is not required in such cases or in case in which the arrestee was indicted by a grand jury prior to his arrest. Step 7, the first appearance. An arrestee who is held in custody or who otherwise remains subject to custodial restraints, as where released on station house bail, must be presented before the magistrate court within a time period specifically specified as either 24 or 48 hours. Since the arrestee is now a defendant, the complaint having been filed, and this is his first appearance in that capacity. This proceeding before the magistrate is described in many jurisdictions as a first appearance, although other jurisdictions use initial presentment, preliminary arraignment, or arraignment on the complaint. Where the accused person was not arrested by the police but issued a citation, see step 2 supra. The 24 to 48 hour timing requirement does not apply, and the first appearance may be scheduled a week or more after the issuance of the citation. The first appearance in a felony case commonly is a quite different proceeding. Initially, the magistrate will inform the defendant of the charge in the complaint, of various rights possessed by the defendant, and of the nature of further proceedings. The range of rights and proceedings mentioned will vary from one jurisdiction to another. Commonly, the magistrate will inform the defendant of his right to remain silent and warn him that anything he says to the court or the police may be used against him at trial. The defendant always will be informed of at least the very next proceeding in the process, which usually will be a preliminary hearing. The magistrate will also set a date for preliminary hearing unless the defendant is at that point waives his right to the hearing. I'm just going to read footnote 15, which says where the pre-arrest investigation was conducted through a grand jury. See step 1 supra, the grand jury is likely to have issued an indictment before the person charged in the indictment is arrestee. Here, an arrestee became a defendant through the charge of the indictment even before he was arrested. So I wonder with Gerstein versus Pugh, if that was grand jury or if that was a warrantless arrest. But we'll find out later in this book. The magistrate will also set a date. Okay, unless a date. So where the felony defendant is not represented by counsel at a first appearance, the magistrate's responsibilities include making certain that the defendant is aware of his right to be represented by counsel, including the right to counsel funded by the state if the defendant is indigent. In some circumstances, the indigency determination is made at the first appearance, and the magistrate indicates an appointment of state-funded counsel on a finding of indigency. In others, the indigency determination will be made prior to the first appearance by a court administrator, public defender, and the assignment of counsel will have occurred prior to the first appearance. One of the most important first appearance functions of the magistrate is to fix the terms under which the defendant can obtain his release from custody pending the disposition of charges against him. The process is described as setting bail. Although release day often is conditioned on non-financial requirements, i.e. curfew, restrictions on travel rather than traditional bail, the posting of a security, cash, or bond, the person released on no more than a promise to appear at trial is said to be released on his own recognizance. Setting bail requires consideration of various information relating to the alleged offense. Example, aggravating circumstances in the offender, prior criminal history, and community ties. This information may be collected prior to the first appearance, typically by a pretrial services agency or at the first appearance itself. In many jurisdictions, various classes of arrests are drug tested, typically using urine sample as part of the pre-appearance information gathering process. Drug testing may also be imposed as a condition of release. Where the magistrate imposes a financial condition, example, requires a bail bond, the defendant is not prepared to meet that condition, the defendant will be held in custody in a jail and will remain there until a financial condition is met or there is a final disposition of the charges. Available statistics indicate that in metropolitan judicial districts, a substantial portion of felony defendants, 30 to 40%, fail to gain their release prior to the final disposition of the charges. Many jurisdictions also have a preventative detention exception to the setting of bail. Here, upon a necessary finding of danger or likely flight, the magistrate does not set release terms, but instead orders that the defendant continue to be held in custody pending final disposition of the charges. Step 8, preliminary hearing. Following the first appearance, the next scheduled step in a felony case ordinarily is the preliminary hearing, sometimes called a preliminary examination, but a handful of our 52 jurisdictions grant the felony defendant a right to a preliminary hearing to be held within a specified period, typically within a week or two if the defendant does not gain pretrial release, and within a few weeks if released. Actual use of the preliminary hearing varies considerably from one jurisdiction to another, and sometimes from one judicial district to another in the same jurisdiction. In many jurisdictions, the prosecution, if it so chooses, can preclude a preliminary hearing by obtaining a grand jury indictment prior to a scheduled date of the hearing. Also, in some jurisdictions, defendants who intend to plead guilty commonly waive the hearing and move directly to trial court. The end result is that preliminary hearings are held in most all felony prosecutions in some jurisdictions, in a substantial majority in others, in a significant minority in still others, and almost never in several jurisdictions. Where the preliminary hearing is held, it will provide, like grand jury review, see step 9 in FREP, a screening of the decision to charge by a neutral body. In the preliminary hearing, that neutral body is the magistrate who must determine whether, on the evidence presented, there is sufficient evidence to send the case forward. Ordinarily, a magistrate will already have determined that probable cause exists as part of an ex parte screening of the complaint. The preliminary hearing, however, provides screening in an adversary proceeding in which both sides are represented by counsel. Typically, the prosecution will present its key witnesses, and the defense will limit its response to the cross-examination of those witnesses. Although the defense has the right to present its own witness and may occasionally do so. if the magistrate concludes that the evidence presented is sufficient for a prosecution to move forward, usually that it establishes probable cause, she will bind the case over to the next stage in the proceedings. In an indictment jurisdiction, see Step 9, infra, the case is bound over to the grand jury, and in a jurisdiction that permits the direct filing of an information, see Step 10, infra, the case is bound over directly to the general trial court. If the magistrate finds that the evidence supports only a lesser charge, i.e. a misdemeanor, the charge will be reduced. If the magistrate finds that the evidence is insufficient to support any charge, the prosecution will be terminated. Step 9, grand jury review. Although almost all American jurisdictions still have provisions authorizing grand jury screening of felony charges, such screening is made only in those jurisdictions requiring felony prosecutions to be instituted by an indictment, a charging instrument used by the grand jury. In a majority of the states, the prosecution is now allowed to proceed either by grand jury indictment or by information at its option, because prosecutors in these states most often choose to prosecute by information. The states providing this option commonly are referred to as information states. 18 seats in the federal system and the District of Columbia currently require grand jury indictments for all felony prosecutions. These jurisdictions commonly are described as indictment jurisdictions. 4 additional states are limiting indictment jurisdictions, requiring prosecution by indictment only for their most severely punished offenses, capital, life imprisonment, or both. In the grand jury, typically is selected randomly from the same pool of prospective jurors, the veneer, as the trial jury. Unlike the trial jury, however, it sits not for a single case, but for a term that may range from 1 to several months, as in the case of the magistrate at the preliminary hearing. The primary function of the grand jury is to determine whether there is sufficient evidence to justify a trial on the charge sought by the prosecution. The grand jury, however, participates in a screening process quite different from the preliminary hearing. It meets in a closed session and hears only evidence presented by the prosecution. So to figure out if there's sufficient information to justify a trial, it's a longer term. Very interesting. Defendant has no right to offer his own evidence or to be present during grand jury proceedings. If a majority of the grand jurors conclude that the prosecution's evidence is sufficient, the grand jury will issue the indictment requested by the prosecutor. The indictment will set forth a brief description of the offense charged, and the grand jury's approval of that charge will be indicted by its designation of the indictment as a true bill. If the grand jury majority refuses to approve the proposed indictment, the charges against the defendant will be dismissed. Step 10, the filing of indictment or information. If an indictment is issued, it will be filed with the general trial court and will replace the complaint as an accusatory instrument in the case. Where grand jury review either is not required or has been waived, an information will be filed with the trial court. Like an indictment, the information is a charging instrument which replaces the complaint, but it is issued by the prosecutor rather than the grand jury. So, in order to keep these under about 15 minutes, step 11 through step 18 will proceed next. Recording. Arraignment on the information or indictment, pretrial motions, pretrial discovery, guilty plea negotiation acceptance, the trial, sentencing, appeals, and collateral remedies will follow.